The Law Factor with advocate Clarence Arenas Gandawa.
The Law Factor, Academic Sovereignty. Who writes the legal curriculum? The verdict speaks. Greetings of the day. When syllabi are borrowed, sovereignty is surrendered. Today, we interrogate the curriculum. Who writes it? Who benefits? And who is erased? Legal education must serve the continent, not mimic the colonizer. This is not reform, it is reclamation. The verdict speaks, every Thursday. Pedagogic sovereignty, without exception.
Across lecture halls and law schools, the curriculum is treated as neutral. But let's pause. Who wrote it? Who benefits from it? And who is erased by it? Legal education is not just about knowledge, it is about power. When syllabi are borrowed from colonial models, they reproduce colonial logic. When textbooks ignore local jurisprudence, they silence local justice. And when students graduate fluent in foreign law, but illiterate in their own, sovereignty is surrendered. Let's be clear. The curriculum is not just content, it is civic compass. It shapes how lawyers think, how judges rule, and how citizens are served. Academic sovereignty means designing syllabi that reflect our realities, our remedies, and our reforms. It is not just pedagogy, it is nation building. Imported syllabi, the colonial echo. Many African law schools still teach British common law as the default. Cases from 19th century England dominate the reading list. But where are the rulings from Babane, Harare, Nairobi, or Kigali? Where are the statutes that govern our land, our families, our futures? This is not education, it is erasure. And it must be corrected with courage through Education 6.0. Case study, the student who questioned the canon. A law student in Eswatini asked why her syllabus included 12 British cases, but none from her own country. Her professor says, that's the standard. She replied, whose standard? She later founded a civic law review featuring Eswatini's own jurisprudence. This is academic sovereignty in motion. Pedagogy reform from casebook to civic campus. Legal education must teach statutory interpretation rooted in local law, customary law as a living system, constitutional rights as civic tools, procedural clarity as public empowerment, because lawyers are not just advocates, they are architects of justice, and their training must reflect the terrain they serve. Let's talk Parliament. Curriculum oversight and reform. Parliament must not ignore legal education. It must fund curriculum reform, mandate local content, and audit law schools for relevancy. Because when the curriculum is outdated, the justice system follows, and outdated justice is injustice. Now, we speak to the public. Citizens must ask, what are lawyers learning? Whose cases are they studying? Whose voices are they missing? Legal education is a public concern, not just an academic one. Because the lawyers of tomorrow shape the laws of tomorrow, and the public must shape the syllabus. Eswatini in focus and the continental mirror. In Eswatini, legal education still leans heavily on external models. But in Rwanda, law schools now teach genocide jurisprudence and reconciliation law. In Kenya, community law is part of the syllabus. In South Africa, customary law is taught alongside constitutional law. Eswatini must recalibrate because sovereignty begins in the classroom through Education 6.0. The curriculum is not just a syllabus, it is a statement of sovereignty. We must write it with clarity, teach it with courage, and revise it with purpose. Because legal education must serve the people, not just the profession. Don't just teach the law, transform it. Don't just follow the syllabus, reclaim it. The law must educate louder. The law moves forward, you must move with it. See you next Thursday. The work continues.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.